From the time I was 8 years old, when my father first took me to a car show in downtown Chicago, I knew exactly what I wanted. While other kids dreamed of becoming astronauts or professional athletes, I had a different goal. I wanted to own a Lamborghini. The poster hung above my bed throughout my childhood, my teenage years, and even my cramped college apartment. Some might call it materialistic. I called it motivation. I grew up in a blue-collar neighborhood where luxury cars only appeared when their owners took a wrong turn. My parents worked hard, dad as a factory worker and mom as a nurse, but exotic Italian supercars were firmly in the realm of fantasy for our family. They taught me the value of hard work and saving, lessons that would shape my entire approach to life. After college, I started a small tech consulting business. The first 5 years were brutal. 16-hour days, missed holidays, and a checking account that sometimes held less than 3 digits. But gradually, client by client, the business grew. I lived frugally, investing every spare dollar back into the company or into my Lamborghini fund. Friends bought houses and took vacations while I rented a modest apartment and worked weekends. 15 years after starting my business, I walked into the Lamborghini dealership not as a dreamer, but as a buyer. The salesman probably doubted me at first. I have never been one for flashy clothes or accessories, but when the financing was approved, his attitude changed completely. I selected an Aventador in Arancio Argus, a brilliant orange that seemed to capture all the fire and passion that had driven me for decades. The day I took delivery was perhaps the happiest of my life. The engine roared to life with a sound that resonated in my chest cavity. The salesman explained the features, but I barely heard him over the pounding of my own heart. This machine represented every sacrifice, every late night, every risk I had taken. I had done it. The impossible dream of that 8-year-old boy was now sitting in front of me, keys in my hand. 3 months before purchasing the car, I had moved into Oakwood Estates, an upscale gated community with manicured lawns and colonial-style homes. The Homeowners Association was known for keeping the neighborhood pristine, which I appreciated. Each home had a 2-car garage and a designated visitor parking space. My garage already held my everyday car and some storage, but the HOA rules clearly stated that the visitor spot could be used by residents when not occupied by guests. The first time I drove the Lamborghini through the community gates, I noticed the stairs. Most were admiring, some curious, but one stood out. A woman in her early 60s with immaculately styled silver hair and designer casual wear watched from her front porch with narrowed eyes and pursed lips. She did not wave back when I raised my hand in greeting. I would later come to know her as Patricia Winters, HOA president for the past 8 years, but everyone in the neighborhood had another name for her, Karen. I parked the Lamborghini in my visitor spot, carefully positioned between the lines, and stood back to admire it. As the garage door closed behind me, I caught movement in my peripheral vision. Patricia was taking a photo of my car with her phone. I thought nothing of it at the time. Perhaps she was just admiring it too. That assumption would prove to be my first mistake in a series of events that would test my patience, my resolve, and ultimately my faith in justice. Oakwood Estates operated under a complex web of rules and regulations. The HOA handbook was 47 pages long, covering everything from acceptable mailbox designs to the precise height grass could reach before requiring a mow. Most residents accepted these restrictions as the price of living in such an immaculate community. I had reviewed the rules before purchasing my home and found nothing prohibiting ownership of exotic cars, nor any restrictions about parking legally owned vehicles in designated spots. 2 days after bringing home my Lamborghini, I found a white envelope tucked under my windshield wiper. Inside was a printed notice on HOA letterhead stating that vehicles must be parked completely within designated spaces. The notice included a photo of my car, which showed it perfectly centered in the spot. I was confused, but decided to be even more careful with my parking going forward. A week later, I was retrieving my mail when Patricia Winters approached me directly for the first time. She wore tennis whites despite no evidence she had been playing, and her smile did not reach her eyes. "You must be doing well for yourself," she said, gesturing toward my garage where the Lamborghini was visible through the window. "Thank you, it has been a goal of mine for many years," I replied politely. "We usually see these kinds of cars in music videos, not in Oakwood Estates," she continued, her voice SW. Eat but with an edge. Our community prides itself on its understated elegance. Flashy items tend to disturb the harmony we have cultivated here. Before I could respond, she patted my arm condescendingly. Just something to consider, dear. We all make sacrifices to maintain our community standards. That night I received another notice, this time claiming my vehicle was leaking fluids in the parking area. I immediately checked both the car and the pavement. There were no leaks of any kind. I took photos as evidence and emailed them to the HOA board address, requesting clarification. My email went unanswered. My next-door neighbor, Robert, caught me as I was documenting the spotless pavement beneath my car. A retired history professor in his 70s, Robert had lived in Oakwood Estates for over a decade. "I see you have caught Patricia's attention," he said quietly. "Word of advice, keep your head down. She has a way of making life difficult for people she takes issue with." "Has she done this before?" I asked. Robert looked around before answering. The Millers had a boat, nothing huge, just a 20-footer they used on weekends. They kept it in their driveway, which was technically allowed by the bylaws if it did not extend past the front of the house. Theirs did not, but Patricia decided it was an eyesore. Citations, fines, threats of liens. They moved out last year. Over the next few weeks, I received 3 more notices for increasingly creative violations. One claimed my car exceeded noise ordinances, though I always drove slowly and quietly through the neighborhood. Another stated the color was not in keeping with the approved exterior palette of the community, despite no such palette existing for vehicles in the HOA regulations. I began taking extreme precautions. I measured the exact center of my parking space and used markers to ensure perfect alignment. I kept a log of when I drove the car and how long it was parked. I installed a small security camera aimed at my parking space. One evening, reviewing the security footage, I saw something disturbing. Patricia was circling my car with a measuring tape and a camera, documenting it from various angles. She spent nearly 15 minutes examining every inch of the vehicle, occasionally making notes on a clipboard. I had a sinking feeling in my stomach. This was not random enforcement. This was targeted harassment, and based on what Robert had told me, I feared it was only the beginning. 3 months after purchasing my Lamborghini, I needed to travel to Seattle for an important client meeting. It would be my first time leaving the car unattended for more than a day. I took extra precautions before departing, parking it precisely in my visitor spot, covering it with a custom-fitted car cover, and asking Robert to keep an eye on it. I even left a note on the dashboard with my contact information in case of any issues. The business trip was scheduled for 4 days, Monday through Thursday. The meetings in Seattle went exceptionally well. We signed a major new client, potentially the biggest in the history of my company. I was riding high on this professional victory as my flight landed back home on Thursday night around 11:30 p.m. The airport was about an hour from Oakwood Estates, and by the time my rideshare pulled up to my house, it was approaching 1:00 a.m. Exhausted but satisfied, I thanked the driver and collected my luggage. As I turned toward my home, something felt wrong. It took my tired brain a moment to process what was missing. My visitor parking space was empty. The Lamborghini was gone. My heart began racing immediately. I dropped my suitcase and ran to the spot, as if somehow the car might materialize if I stood directly in the empty space. The car cover lay discarded near some bushes, partially folded as if removed in a hurry. There were no glass fragments on the ground, no signs of forced entry or hot wiring. My mind struggled to make sense of the situation. I pulled out my phone with shaking hands and dialed 911. "I need to report a stolen vehicle," I told the dispatcher, my voice cracking slightly. "A Lamborghini Aventador orange. It was parked in my designated spot when I left town, and now it is gone." 2 police officers arrived within 20 minutes. They took my statement, examined the parking spot, and collected the car cover as potential evidence. One officer remained skeptical from the start. "Are you sure no one else has access to the vehicle?" he asked. "These kinds of cars do not typically get stolen without keys." "I have both sets of keys with me," I insisted, showing them the distinctive Lamborghini key fob, "and I have security camera footage of the spot." I pulled up the app on my phone, only to discover that my camera had been disabled sometime Tuesday afternoon. The last footage showed nothing unusual, just my covered car sitting in the spot. "We will put out an alert for the vehicle," the officer said. "With something this distinctive, it should be easy to spot if it is still in the area." As they were preparing to leave, the senior officer received a radio call. He stepped aside to take it, then returned with an unexpected update. "Sir, dispatch just informed me that your vehicle was not stolen. It was towed on Tuesday afternoon at the request of your homeowners association for parking violations." I stared at him in disbelief. "That is impossible. I was parked legally. Where did they take it?" "Apparently to Jameson's Towing on Highway 16. They are closed now, but you can follow up with them when they open at 8:00 a.m. I spent the rest of the night in a state of anxious confusion. How could the HOA authorize a tow when I was parked perfectly legally? Why had no one contacted me? I called every emergency number listed in the HOA handbook, but received no answer. Sleep was impossible as my mind raced through possible scenarios and next steps. At 7:45 a.m., I was already in my everyday car, heading to Jameson's Towing. The facility was a large fenced lot with a small office at the entrance. As I pulled in, I scanned the rows of impounded vehicles, looking for the distinctive orange of my Lamborghini. I did not see it among the visible cars. The office was staffed by a heavy-set man with a gray beard who introduced himself as Mike. When I explained the situation, he checked his computer. "Yeah, we got an orange Lambo here. Came in Tuesday around 3:00 p.m. HOA request from Oakwood Estates." "I need to see it immediately," I said. Mike hesitated. "Look, before I take you back there, I need to tell you something. There was an incident during transport." My blood ran cold. "What kind of incident?" "The car, it got damaged during loading. The driver was not familiar with exotics. These low-clearance vehicles require special equipment that we do not normally use." I felt lightheaded. "Take me to my car now." Mike led me through a side door and across the lot to a separate fenced area in the back. And there it was, my Lamborghini, my dream, my reward for 15 years of sacrifice and hard work, except it was no longer the masterpiece of Italian engineering I had purchased. The front splitter was completely destroyed. Long, deep scratches ran along both sides where the car had scraped against the tow truck ramp. The rear diffuser was cracked in multiple places. One of the scissor doors was bent at an unnatural angle, clearly damaged from improper lifting. The custom wheels were scuffed beyond recognition. Worst of all, the carbon fiber monocoque, the literal backbone of the vehicle, designed to withstand racing speeds, had a visible crack running along one side. I circled the wreckage slowly, each new angle revealing another devastating injury to the machine I had loved. This was not simple cosmetic damage. This was catastrophic. Even if repairs were possible, the car would never be the same. Its value had plummeted in an instant. "Who authorized this?" I finally managed to ask, my voice barely above a whisper. Mike checked his paperwork. Request came from a Patricia Winters, president of Oakwood Estates HOA. Said you were in violation of some section about commercial vehicles not being allowed in residential spots. The absurdity of classifying a personal Lamborghini as a commercial vehicle might have been laughable under different circumstances. But standing there, looking at the ruins of my dream, I felt only a cold, resolute anger taking hold. Someone would answer for this destruction, and I already knew exactly who that someone was. "I want to speak to whoever towed my car," I demanded, still struggling to process the devastation before me. Mike shifted uncomfortably. "Joe handled the tow, let me get him for you." A few minutes later, a lanky man in his 30s with a company uniform approached. He looked nervous, avoiding direct eye contact. "Are you the one who towed the Lamborghini?" I asked, fighting to keep my voice steady. "Yes, sir," Joe admitted. "Look, I am really sorry about what happened. In 15 years of towing, I have never dealt with anything like that car." "Did you use specialized equipment, low-angle loading, soft straps, wheel nets?" I asked, naming the standard protocols for towing exotic vehicles. Joe looked even more uncomfortable. No, sir, we used our standard flatbed. The boss did not tell me it was anything special, just an address and a vehicle description. A bright orange Lamborghini did not strike you as something that might need special handling. I could not keep the incredulity from my voice. By the time I realized it needed different equipment, we were already committed to the load, Joe explained. The car was so low that it scraped immediately on the ramp. Once it started, there was no good way to stop without risking more damage. I called in for guidance, but was told to complete the tow anyway. Who told you to complete it, Desp? Ite the damage. The lady from the HOA was there supervising. She said to continue regardless. This revelation hit me like a physical blow. Patricia had watched my car being destroyed and encouraged it to continue. I need to see any documentation authorizing this tow, I said to Mike, who had been standing nearby listening, and I need copies of all your security footage. Mike hesitated. The footage is automatically deleted after 48 hours unless we flag it for retention. And did you flag footage of a Lamborghini being damaged during loading? I asked incredulously. No, sir, I did not know about the incident until this morning. I took a deep breath. What about the tow authorization? You must have paperwork. Mike produced a single sheet with a basic form. The violation cited was commercial vehicle in residential parking, with Patricia Winter's signature and a timestamp of Tuesday, 2:37 p.m. There were no photographs documenting the alleged violation, no reference to specific HOA bylaws, and no evidence that the HOA board had approved the action. I paid the impound fee under protest, arranged for a specialized exotic car transport to take the Lamborghini to the nearest authorized service center, and headed directly to the HOA office at our community clubhouse. The office was typically staffed by a part-time administrator on weekday mornings. The administrator, a pleasant woman named Diane, looked startled by my intense demeanor as I entered. I need copies of all documentation related to the towing of my vehicle on Tuesday, I stated. What vehicle and address? She asked professionally. When I provided the details, she searched through both physical files and the computer system. I do not have any towing authorizations processed this week at all, she finally said, looking confused. Check under Patricia Winter's authorizations specifically, I suggested. More searching, nothing here. All HOA actions require board approval and documentation. Towing especially needs at least 3 attempted contacts with the owner, photographic evidence of the violation, and a board vote unless it is blocking emergency access. This was exactly as I had suspected. Patricia had acted completely outside of proper channels and protocols. I need a copy of the complete HOA bylaws and all board meeting minutes from the past 6 months, I requested. Armed with this documentation, I drove directly to Patricia's house. Her luxury SUV sat in the driveway, and I could see her tending to flowers in her front garden. She straightened up as I approached, her face momentarily registering surprise before settling into a composed mask of authority. "Can I help you?" she asked coolly. "You had my car towed while I was out of town," I stated flatly. "The towing company destroyed it because they were not equipped to handle an exotic car. You were present and instructed them to continue despite the damage occurring." Patricia adjusted her gardening gloves. "Your vehicle was in violation of community standards. As HOA president, I have a responsibility to maintain those standards." "What specific violation?" I demanded. "Commercial vehicles are not permitted in residential parking spaces," she replied without hesitation. "My personal Lamborghini is not a commercial vehicle by any definition, and according to HOA bylaws, you had no authority to order that tow without board approval and proper notification." Something flickered across her face, perhaps the realization that I had done my homework. "The board has granted me discretionary authority for routine enforcement," she claimed. "Show me where that is documented," I challenged. Because I have just come from the HOA office and they have no record of any tow authorization, no evidence of violations, and no emergency action approval. Patricia's expression hardened. Listen to me carefully. People like you with your flashy cars and new money do not belong in Oakwood Estates. This community has standards, traditions. That orange monstrosity was an eyesore that brought down property values and attracted unwanted attention to our neighborhood. The mask had slipped. This had never been about rules or violations. This was about Patricia Winters deciding what and who belonged in her domain. That orange monstrosity, as you call it, was worth over $400,000 and is now severely damaged due to your unauthorized and illegal actions, I replied, my voice dangerously calm. Actions that were taken without proper authority, without documentation, and apparently out of personal prejudice. Patricia's face flushed. Do what you want. The HOA has excellent lawyers. You will find that I acted within my rights as president. As she turned to walk back to her house, I called after her. One more question, Patricia. When you watched the tow truck operator struggling with my car, when you saw the damage beginning to occur, why did you instruct him to continue anyway?
She
Paused but did not turn around. Some lessons cost more than others, she said before disappearing inside her home. In that moment, I knew this was not simply about getting compensation for my damaged vehicle. This was about holding accountable someone who had abused their power out of spite and prejudice. Patricia Winters had made a serious miscalculation. She thought she was teaching me a lesson. Instead, she had given me a cause. The first attorney I consulted was not encouraging. HOAs have broad enforcement powers, he explained. Even when they overstep, the courts tend to defer to their authority in managing their communities. I thanked him for his time and moved on. The second attorney, a woman specializing in property disputes, showed more interest but cautioned that the case would be challenging. The damage occurred during towing, which the towing company will claim was necessary due to the vehicle's design. Their insurance will fight this hard. It was the third attorney, Maxwell Brenner, who truly understood what had happened. A former prosecutor turned civil litigator, Max specialized in cases of authority abuse. He listened carefully to my story, examined the documentation I had gathered, and asked pointed questions about Patricia's behavior both before and during the incident. This is not just negligence, Max concluded. This appears to be intentional and malicious. The HOA president knowingly exceeded her authority, targeted your property specifically, and then watched as it was damaged without intervening. In fact, she encouraged further damage. That moves this from a simple property dispute into the realm of intentional tort. We began building our case methodically. The first step was having the Lamborghini professionally assessed. I transported it to the nearest authorized Lamborghini service center, where factory-trained technicians performed a comprehensive evaluation. Their report was grim. The damage totaled $289,735 in parts and labor. Worse, they noted that even with repairs, the vehicle would forever carry a diminished value of approximately 40% due to the structural compromise of the carbon fiber chassis, a loss of an additional $160,000. With the damage assessment in hand, we gathered evidence from multiple sources. First, I hired a forensic HOA specialist who reviewed Oakwood Estates bylaws, procedures, and meeting minutes. His conclusion was unequivocal. There exists no provision granting the HOA president unilateral authority to order vehicle towing except in cases of emergency access blockage. The proper procedure requires documented violations, owner notification, and board approval. Next, we obtained statements from Diane at the HOA office confirming that no official towing authorization had been processed and no board vote had taken place regarding my vehicle. We also secured an affidavit from Joe, the tow truck operator, stating that Patricia had been present during the towing and had specifically instructed him to continue despite visible damage occurring to the vehicle. His statement included the damning quote, "She told me to keep going even when I expressed concern about the damage, saying he should have thought about that before bringing that thing into our neighborhood." Most surprisingly, 3 days into our case preparation, I received an unexpected phone call. "This is Thomas Blackwell," the caller said. "I am on the HOA board at Oakwood Estates. I understand you are building a case regarding your vehicle." I confirmed cautiously, wondering if this was some kind of trap or intimidation attempt. "I would like to meet with you and your attorney," Thomas continued. "There are things you should know about Patricia Winters and how she has been running this HOA." The meeting took place at Max's office the following day. Thomas, a distinguished man in his 60s, explained that he had been on the board for 5 years and had witnessed Patricia's gradual consolidation of power. "She has been targeting residents she personally disapproves of for years," he explained. "Several board members have expressed concerns about her methods, but she controls access to legal counsel and financial information. When we question her actions, she claims they have been approved in emergency sessions that somehow only include her allies." Thomas provided copies of internal communications showing that Patricia had specifically mentioned my Lamborghini in a board email chain, writing, "This type of ostentatious display is exactly what we have worked to prevent in Oakwood Estates. I will handle the situation." Several board members had responded asking for clarification and proper procedure, which Patricia had ignored. Most importantly, Thomas revealed that the HOA's legal counsel had actually advised against any action regarding my vehicle, stating in an email, "The vehicle in question does not meet any reasonable definition of a commercial vehicle, and its parking appears to comply with all relevant bylaws. We strongly advise against enforcement action in this case." Patricia had received this advice, yet proceeded anyway. "Why are you coming forward now?" Max asked Thomas. "Because this has gone too far," he replied. "We all wanted a nice neighborhood, not a dictatorship, and destroying someone's property out of personal prejudice crosses a line that I cannot ignore." With Thomas's testimony and documentation, our case transformed from strong to overwhelming. Max prepared a formal legal complaint naming both the HOA and Patricia Winters personally as defendants. The complaint alleged: 1. Abuse of authority and violation of HOA procedural requirements. 2. Intentional infliction of property damage. 3. Fraudulent misrepresentation to the towing company. 4. Negligence in the selection of an inappropriate towing service. 5. Violation of my rights as a community member. As Max filed the lawsuit with the county court, he explained the strategy. "We are asking for full compensation for the physical damage, diminished value, rental car expenses, and legal fees. But we are also seeking punitive damages against Patricia personally for her malicious conduct. The HOA insurance will likely cover the compensatory damages, but punitive damages typically come out of the defendant's own pocket." The lawsuit was filed on a Friday afternoon. By Monday morning, the story had spread throughout Oakwood Estates. Neighbors I had barely spoken to before were approaching me with their own stories of Patricia's tyranny. The balance of power was shifting, and for the first time since my car was destroyed, I felt a sense of hope. The system that Patricia had manipulated for so long was about to hold her accountable. The HOA's insurance company wasted no time in bringing in high-powered attorneys from a prestigious downtown firm. Their initial strategy was predictable: file for immediate dismissal, claiming the HOA had acted within its rights and that any damage was the sole responsibility of the towing company. Our first courtroom appearance was for the dismissal hearing. The judge, an older woman named Judge Alina Harmon, listened patiently as the HOA attorney made his case. "Your Honor, homeowners associations are granted broad discretion in enforcing community standards. The plaintiff was aware of these standards when he chose to live in Oakwood Estates. The damage to his vehicle, while unfortunate, was a result of the vehicle's unusual design and the towing company's methods, not any action by the HOA." When it was Max's turn, he approached the matter differently. "Your Honor, this case is not about routine HOA enforcement. It is about one individual who deliberately exceeded her authority, ignored established procedures, disregarded legal advice, and then stood by watching, even encouraging, as the plaintiff's property was destroyed. This was not enforcement, it was targeted malice. Max then presented our evidence: the lack of board approval, the legal opinion advising against action, the testimony of the tow operator, and Thomas Blackwell's affidavit. Judge Harmon studied the documents carefully before looking up. I find sufficient cause for this case to proceed to trial. The plaintiff has presented credible evidence of procedural violations and potential malicious intent. Motion to dismiss denied. Outside the courtroom, the HOA's attorney approached us with an offer: $150,000 to settle the case immediately. Max and I exchanged glances. "That would not even cover half the repair costs," I replied. "Consider carefully," the attorney warned. "Trials are unpredictable and expensive." Max smiled thinly. "So is willfully destroying a $400,000 vehicle. We will see you in court." The trial began 3 months later. The courtroom was more crowded than I expected, with many Oakwood Estates residents attending. Patricia sat at the defense table looking confident and immaculately styled, occasionally whispering to her attorneys. Expert witnesses formed the backbone of our case. The Lamborghini technician explained in detail why the damage was catastrophic rather than cosmetic. "This is not like damaging the body of a standard vehicle. The carbon fiber monocoque is the structural heart of the car. Once compromised, it can never be restored to factory integrity." A towing specialist testified about proper exotic car handling procedures. Any reputable towing service knows that vehicles with ground clearance under 5 inches require specialized equipment. The moment the operator saw the vehicle type, the tow should have been refused or alternative equipment requested. Patricia's testimony was a study in controlled arrogance. She remained composed under direct examination, insisting she had acted within her authority. "As HOA president, I am responsible for maintaining community standards. The vehicle in question was an unauthorized commercial vehicle based on its extreme DACI. GN and attention-drawing color." During cross-examination, Max approached her methodically. "Ms. Winters, can you point to the specific bylaw that classifies a privately owned Lamborghini as a commercial vehicle?" Patricia hesitated. "The bylaws prohibit vehicles that disrupt the residential character of the neighborhood." "That language does not appear anywhere in the bylaws," Max countered, displaying the relevant section on the courtroom screen. "In fact, the commercial vehicle section specifically defines commercial vehicles as those with business markings, commercial registrations, or exceeding certain height and weight limitations. The plaintiff's vehicle met none of these criteria." Max then produced the email from the HOA's own attorney advising against action. "Did you receive this legal opinion before ordering the tow?" "I receive many emails," Patricia replied evasively. "Yes or no, Ms. Winters, did you receive this specific legal advice before taking action against my client's vehicle?" "Yes," she finally admitted. "And did you share this legal opinion with the board before proceeding?" "There was no time for a full board consultation." "No time," Max repeated incredulously. "The vehicle had been parked legally for months. What emergency required immediate action specifically while the owner was out of town?" Patricia had no good answer. The most damaging testimony came from Joe, the tow truck operator. He described in detail how the car immediately began suffering damage during loading. "I told Ms. Winters that we should stop and call for specialized equipment," Joe testified. "She told me to continue anyway. When I pointed out the damage that was already occurring, she said, and I remember this clearly, that is his problem for bringing that monstrosity here. Maybe next time he will think about whether he really belongs in this neighborhood." The courtroom murmured at this revelation. I glanced at Patricia, whose composed facade had finally cracked, her face flushed with anger or embarrassment. Thomas Blackwell's testimony about Patricia's pattern of selective enforcement and procedural violations further strengthened our case. He produced years of documentation showing how she had targeted certain residents while ignoring similar issues with her allies. In closing arguments, the HOA's attorney tried to salvage their position. Even if proper procedures were not perfectly followed, there was no malicious intent. This was, at worst, an administrative error. Max's closing was brief but powerful. Your Honor, this case is about abuse of power in its most basic form. Patricia Winters decided that my client and his car did not belong in her community. Rather than following established procedures or respecting legal advice, she deliberately orchestrated the destruction of his property to send a message. She watched as it was damaged and encouraged further harm. This was not enforcement. It was punishment for failing to conform to her personal vision of what Oakwood Estates should be. The law cannot allow such arbitrary and malicious abuse of authority to stand unchallenged. As Judge Harmon adjourned to consider her verdict, I noticed something had changed in the courtroom dynamics. The residents of Oakwood Estates who had come to observe were no longer sitting in clearly divided camps. Many who had arrived with Patricia were now avoiding her gaze, some even nodding respectfully to me as they left the courtroom. The truth had a power all its own, and it was already reshaping my community before the verdict was even announced. 1 week after closing arguments, we returned to the courtroom for Judge Harmon's verdict. The room was even more crowded than before, with what seemed like half of Oakwood Estates in attendance. Patricia sat stiffly at the defense table, her attorney whispering final reassurances. Judge Harmon entered and called the court to order. She took a moment to organize her notes before speaking. Having carefully considered all evidence and testimony in this matter, I am prepared to render judgment, she began. This case presents important questions about the limits of authority within self-governing communities and the responsibility that comes with such authority. She addressed each aspect of our claim methodically, building toward her conclusion. I find that the defendant, Patricia Winters, acted without proper authorization under the HOA bylaws when ordering the plaintiff's vehicle to be towed. The evidence clearly establishes that proper procedures were not followed, require.